Yes, is my screen visible? Hi, Ayan. Is my screen visible? Can you confirm?
Yes, it is visible.
Alright. So today we'll be talking about how to read a judgment effectively and how to prepare a case summary, also called a case brief out of it. It will be a shorter session since I'm not very well. So we'll be talking about some key pointers which you should consider while reading a judgment. Since judgments are commonly very lengthy and it is like often very boring to read lengthy judgments. So how to read those judgments effectively and how to take notes and make a case summary out of it. So before moving into that, we need to understand firstly what a judgment actually means. So judgment is a decision of a court adjudicating the rights of the parties to a legal action before it. In simple words, if I can define a court's judgment is like the final decision of a judge that is made in a legal case. It is when the court says what should happen based on the laws and
Sir,
evidences
your voice is
presented
breaking.
during the trial. My voice is breaking.
Yes, your voice is breaking.
Is it now? Is it now?
No, sir, it's still not breaking.
Wait a minute. Wait a minute. Is it better now?
Yes, sir.
Alright.
Yes, sir. It's very good now.
So, as talking about what a judgment is, court judgment is like the final decision of the court in any case. In the judgment, the court holds what should happen based on the laws and evidences presented during the trial process. It also involves the final decision who is right or wrong in a particular case and what consequences or actions need to be taken. Now, be it for law students or for any legal professional or any other person concerned, reading lengthy judgments seem like a nightmare, right? Because ordinarily judgments are so long that we often feel bored while reading judgments. Some judgments are more than 500 or 1000 or beyond pages. So you need to accept that you might not understand a case at first reading, no matter what level of comprehension do you have or how much of grammar skills do you own. You need to accept the fact that the cases and the judgments are written in a complex language with a lot of legal jargons are used and a lot of legal maxims are used. So it is quite difficult for us to understand completely and the case in entirety at its first reading. So you need to read it several times, maybe twice, maybe thrice, or maybe even more. And the most important thing is this is a human tendency. Like whenever we read lengthy text or lengthy judgments, we tend to forget things, whatever we read earlier. So while you read, make sure that you are taking notes of the important pointers that you go through. For example, if you are reading a judgment, uh, firstly write who are the parties, what was the cause of action, what persuaded the plaintiff or the victim to approach the court, what prayer did they seek for, and what were their arguments, what was the court's reasoning, what was the dissenting opinion. So you need to take note of each in order to um, have have things organized at your place. No, for you to understand the facts, you need to focus on mainly three things. Firstly, what has happened that has provoked someone to take this case to court. It is basically the cause of action that persuaded a party to approach the court. Let's say it's let's say it is a matter of murder. So murder happened, and that's why the victim approached the court, or the state on behalf of the victim approached the court. So it is the cause of action. Like any case, there must be a cause of action. There must be some happening which led the party to go to the court. So you need to understand firstly what was the reason due to which the party was compelled to go to the court and take a suit. Secondly, if it is case of appeal, you need to firstly understand what happened at the trial court and maybe the other lower courts, and what provoked someone to appeal, to go for appeal in that particular case. Thirdly and lastly, what did the higher court do with this case? Maybe if the appeal has been filed in the high court of any concerned state. So what was happened in that case? Was it further appealed? Was it finally decided by that court, or like, whatever happened? You need to take note of that. Now, there are four main parts of any judgment. Firstly, the facts and the background of the case. Facts are nothing but the happenings which persuaded a party to go to the court. Like there must have happened something so that the party approached the court, right? That is the fact and background of the case. Secondly, the legal issues involved in the case. In any case, there are two parties, and there must be some points where the two parties are not agreeing. Like there is a point at which both parties present different opinions. That is something called the legal issue. You need to understand that legal issue is always written in form of a question. It is generally started with the word whether and ends with a question mark. Let's say it may go like whether Article 14 is being violated, whether Article 15 is being violated. So this can be a legal issue. You need to understand that in the higher courts, mainly the questions of law are dealt, and the questions of fact are majorly dealt at the trial level courts. And the cases which you have to choose in order to make case summary or case brief are the ones which are majorly dealt by the higher courts, and the questions of law are decided. So you need to choose a case in which some legal precedent was set or some legal principle was evolved. You do not you are not supposed to choose any case in which only the material facts are there and the factual questions were dealt by the trial court.
So, sir, please, can I have a question?
Yes, yes, please.
If I am taking a case law to my arguments, should it
Mhm.
the decision be final, or should or it can be primary decision for the court?
Can you just rephrase your question?
Okay, in my arguments, I
Mm-hmm.
want a case law that will support my arguments. If I
Mm-hmm.
took a judgment from a court that is primary, can I do this, or I only can take a final decision from the court in that
Um,
case?
try try to go for a case in which final decision was held, because at primary level, basically the question of facts are dealt. So try to choose a case which has been decided finally by the higher authority. That would be
Mhm.
proper.
Okay, thank you.
All right. So we were talking about the legal issues. So legal issues are nothing but a point of questions in which the two parties agree and which are finally decided by the court. Thirdly, the third main part of any case or any judgment is the argument part. In any case, both parties are supposed to put forth their arguments and evidences in support of their claim. So that is the argument. Lastly, analyze after carefully analyzing the arguments of both the parties and by following the principles of natural justice, the court reaches a particular decision or contention after proper consideration of the witnesses and the evidences. And the decision that the court provides is properly backed by the rationale or reasoning behind it. So it's not that the court randomly says something; it must give some reason why the court decided that way or this way. So that is the court's rationale. Now, some important points which you should consider. You do not need to read each and everything. Like if you're reading a 800 pages long judgment, you do not read each word and each part of the judgment. There are some parts which are absolutely useless, and there are some parts which you need to just skim through it, and that are of not great significance as far as preparing case summary is concerned. So you need to find out what not to read more than what to read. And again, as reiterated again and again, you need to read multiple times in order to understand a case in entirety. You cannot expect yourself to, get everything understood at reading once. So you need to read, and read. Now, talking about a case summary. A case summary, also known as a case brief, is a concise or a summarized form of the case. It is an overview of a judge's legal opinion on a particular case. It outlines the essential facts and key points that was determined by the court. Now, talking about the format of case summary, firstly, you need to, at the very first, you need to write the case name and the uh, neutral citation for it. It may be like SCC citation if it is an Indian case, or AIR citation would work. Do not put Indian Kanun link because that is not a reportable source. After that, you can outline the parties which are involved in that case. Thereafter, the main body of the case summary starts. Firstly, you need to briefly state the facts of the case. Thereafter, you need to include what legal issues were decided by the court. You need to numberize those legal issues, like if there are two major issues, issue number one and issue number two. Thereafter, argument for the, if it is a civil case, argument of the plaintiff and argument of the defendant. Thereafter, what was held by the court in that particular case, that is the judgment. So you have to specify explicitly what was held in that particular case. Thereafter, you have to provide the court's rationale behind that holding. So in this, you have to provide what reasoning was employed in this and by the court, uh, and by what reason the judges came to that point of contention or that point of conclusion. Lastly, in conclusion, you have to basically summarize what was concluded in that case, what was held in that case in a very summarized form. And here you can add your analysis as well. Like, what do you feel about this particular judgment? And again, another thing is in any judgment, and there are two opinions. Firstly, the majority opinion, and the second one is dissenting opinion. If it is a uh, if it is a five-bench judgment, there may be a case uh, where three judges held something and two judges were of the dissenting opinion. So you have to briefly state the dissenting opinion as well. That would create a good pattern. your case brief. Now, some important things to consider. Do not include unnecessary points. As the name it suggests, it is a summary or it is a brief. So you have to state everything in a brief and concise manner and do not include unnecessary points. Otherwise, it would be like another judgment by you. Keep it short and concise. You write in proper format as we discussed. Use very simple language, because if you use complex language there is no sense of preparing a case summary, because judgment is already in a complex language, so you need to simplify the actual judgment, right? As we did in articles, you have to avoid plagiarism in case summaries as well. Do not just copy paste someone else's case summary and produce it as your own. You have to write by your own. Please keep a note of it. Also, revise it multiple times. Once you prepare any case summary, you need to cross check things whether you have done it right or not. That is a general rule for every writing. Okay, that's all. We have came to the end of the PPT. So what we'll now do, we'll just take any random judgment and we'll just see how to extract facts, how to extract legal issues, and how to extract arguments and other parts. Okay. All right. So let's take a random case. For example, it is one of the very landmark cases, National Legal Service Authority versus Union of India, in which it was held that there is third gender, that is the transgender community. Okay, see. So whenever you read any judgment, firstly see which court has decided it. So here you can see the Supreme Court of India has decided this case, and this is the petitioner. Petitioner name goes first. See here, this is one of the party who has filed a petition, National Legal Services Authority, and this is Union of India who is a respondent. So see, this judgment is like very lengthy, right? So you are not supposed to read each and every line and each and every sentence in order to understand this case. Firstly, see, most probably you will get the facts in the initial paragraphs itself. For example, if you see the first paragraph, this is some background you can include in your case. See, here in paragraph 2 itself, we can see what the petitioner has prayed. Okay. So from here you can extract your legal issues, like whether the non-recognition of their of do not use their non-recognition of the third gender identity violates Article 14 and Article 21 of the Indian Constitution. So this will be a legal issue which has been majorly been dealt in this case. So you can include this in the issue part. Now here is a brief description about the petitioner, so you can include this in your facts and background part. See, all of this is part of the fact and background. You need to ensure that you write this in a very simple manner and write only the things which are you feel are important and uh, are necessary to understand the fact. Do not include unnecessary information. See here, historical background of transgenders in India has been given. So you need not to read this all because these are just for reference and are not necessary for preparing a case summary. You need not to include these things. This is just for general information. Here, gender identity is being defined, sexual orientation is being defined. You can see these parts. Right version. Also, what United Nations and other human rights bodies think of gender identity and sexual orientation is of no use for us. Also, the Yogyakarta principle is of no use. You can just skip these things. See, there is a lot of unnecessary information given. Like this is a foreign case. Christine Godwin was United Kingdom. Whatever the court said is not of a great significance. You can read that, and if you feel there is something important which you should mention in your case brief, please do that. But lastly, this part is not something we should be concerned about. Again, legislation in other countries on transgenders, we are not very much concerned about this. You see this paragraph in who only recognizes the pattern of binary genders of male and female. So this is of some use.
Manish, your audio is not clear.
No, is my voice not audible?
It is not clear, sir.
It is audible, right? Now, from this part, there is information like Article 49 transgenders. In these parts, you will find how transgenders and denial of transgenders as third gender violate Article 14 or not? You will find the answer in these paragraphs. So you need to read these paragraphs very carefully because these information are very important. Again, Article 15 and 16 and transgenders. These are the important paragraphs. You have to
Sir,
read
your
it
voice
carefully
is
and
breaking.
move. Hello. Is the voice audible now?
Yes, sir.
All right. Okay, so I was telling, like, in between there are a lot of there is a lot of stuff that is of no use for us. So you need to filter out those in order to save your time and effort. Now, here you can see Article 14 and transgenders. So this is a very significant part which you have to include in your case summary, because in this part you will find whether the denial of the recognition of third gender for the transgenders is violative of Article 14 or not. So here is the reason for that. So you have to read it very carefully. Again, Article 15 and 16 and transgenders. This is very important part. So you need to learn how to filter out the important things and how to find what not to read and what is not actually important for us. Again, this is important because these are talking about the Indian legislations and their relation with the main legal issue, right? This is absolutely of much use for us. Again, Article 21 and the transgenders. These are the main legal issues. So you need to read each of the sentences. Now, here comes the legal recognition of third gender self. Okay, again, here are some unuseful information. See from here, the last you will mainly find the judgment part in the last, so you can directly move to the last if you are concerned about the judgment. So in this, you can see how the court is giving reasons and how it is justifying the recognition of the third gender. It is saying how it is violative if we do not recognize the third gender of transgenders. It is violative of Article 21, 14, 15, 16, 19, 21. So these are the reasoning and the court's rationale. See, it is the final holding. We therefore conclude that determination on the basis of sexual identity and discrimination. So here the court is holding in favor of NALSA or the transgender community. This is nothing but the analysis of the precedent that has been set by the court. These are all the court's rationale. Okay, see this paragraph. We therefore declare Hijra's what is this word? Apart from the binary gender, be treated as a third gender for the purpose of safeguarding their rights under Part 3 of our Constitution and the laws made by the Parliament and the state legislature. So these things are part of the final judgment or the final holding of the court. So you can directly take things from here in your brief and include that in the court's holding part. Okay, so I hope you had a little idea about how to read judgments. Also, since it has been recently introduced in the Indian Canon website, you can directly filter out facts, issues, petition arguments, respondent arguments, analysis of the law, precedent analysis, court's reasoning, and the conclusion. I'm not aware how well this works, but you can figure it out. You can just take on facts and the paragraphs which are related to facts will be highlighted. Same for issues. The relevant paragraphs will be highlighted. So you can use this and figure it out how well it works. I have not tried this yet. All right. So you can, if you want to download the PDF of the document, you can do this from here. If you do have access to SCC or Manupatra, you can download from there. And this was a brief session about how to write case summaries. Is my voice audible? Because I think I got disconnected in between. Limit of words, Shwarya, you can find the same in the internship guidelines PDF. Okay, how to write citation. You do not need to write citation, you have to find it from the internet. If you have access to SCC, you can directly find the citation there, or you can just type it out on the Chrome, like the citation for this and that case. I think you will be finding that in Google as well. In Indian Kanun, sometimes citation is there, sometimes it is not written, so you cannot rely on that. You can just Google it and find it out. Format style. What do you mean by format style? Citation format. Like which citation are you talking about? Citation of the case, or you're talking about the referencing thing? Is there any format to write it? I mean, there is a general format. I'll send you about the format to write case. We dealt it in the PPT, right? Format of the case. Okay, Jyoti, you can do one thing like text me on WhatsApp. I'll explain you there. All right. Any other questions? Any other questions, please? Our network is not very stable, so if there are any questions, please go ahead with your questions. Otherwise, we'll call it a day. All right, we imply that there are no questions. All right, since there are no questions, we are ending the session. Thank you all for joining. We hope you learned something and you learned about the format of the case brief. Should you have any questions, you can directly ask me on WhatsApp or you can get me a call also. I'll be very happy helping you out with things. And all the best for your further tasks. And please submit your task on time so that your internship certificate does not get delayed. Alright, with this, I hope you would have found this session helpful. Thank you all, and good night, everyone.